Prosecution, defense, how are we doing today?
We're
Crickets are
getting
nice
there.
too. Well, at least someone answers me. Alrighty, so today we're here for case number DPS 1998 Reopen 004. Let's see here. Alrighty, so we currently have the state of Texas v. We'll say Mayor Jefferson for the accused crime of murder. Alright, we'll start with the prosecution opening statement.
Yes. Today, the state aims to prove that the mayor, Jefferson, did in fact use excessive force on a detainee in custody that unfortunately resulted in their death. We'll be highlighting evidence and have no witnesses, as the evidence will show. Good day.
Alright, we'll now move to the defense's opening statement.
Ladies and gentlemen, Your Honor, to whom it might concern, today I am defending Mayor Jefferson from the allegation of murder. I'm going to use witnesses, evidence, and proof to show that not only is this an accusation, but it is a false accusation. So today I'm here to clear the name of Mayor Jefferson, and I'm here to redeem his character to show that he did act in the way he was trained and taught by the Harris County Sheriff's Office and is being backed by the Harris County Sheriff's Office. Thank you, Your Honor.
Perfect, thank you. Alright, if I could please have all three of you please come up here and stand by me. Stand over here. Alright, that works. Please hold on. Alright, please raise your right hand and repeat after me. I swear that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
I swear the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
Splatter. Splatter. Hello? Can you guys hear?
Yes, Your Honor.
Splatter, are you here?
I swear that this here evidence here is the whole truth, nothing but that.
Okay, you all may be seated. Thankful. Alrighty then. Okay. We'll now move to the presentation of the plaintiff's case. Alright, so let's see. Okay, prosecution at this time, feel free to provide any evidence and or witness testimonies that you feel are necessary.
Yes, so the prosecution will be submitting the CCTV footage captured from the hospital, as well as the HCSO's use of force policy and requirements to search.
Alrighty.
I will send you.
Alrighty. If you hear barking in the background, sorry.
The evidence has been submitted to do, Your Honor.
Alright. I'm gonna kill it all. Alrighty. Alright, let's go ahead and watch this video.
Chan, I'm dead. I found.
Get down there.
You can leave me down there.
Alright, prosecution.
Make it known that out of roleplay, this is from a CCTV thing. You cannot voice the suspect from behind the vehicle.
Yes, we made Jefferson and I made the appropriate modifications to make it look more CCTV time period effective.
Alright. Prosecution, can you please explain what we just saw?
Yes, of course. What we just saw is a CCTV video captured from the corner at the hospital of the HCSO deputy, Jeff Jefferson, removing a suspect from his car, a detainee, in fact, and shooting him point blank in the face with his service weapon. In this video,
Alright.
we of course see the suspect is in fact in handcuffs and being transported, and has not made any visible movement of aggression towards the officer.
Alrighty. Can you please explain the other evidence provided? Or is this just the use of force policy?
So the second piece is just the use of force policy for HCSO, which clearly outlines when lethal force is to be used against a suspect, which, according to their use of force, is life-threatening, seen as someone who poses a direct threat to one's life. Officers are directed to use deadly force to prevent loss of life of an officer or citizen. In this case, in the video we just witnessed, there did not appear to be any direct threat of life to the officer or any other civilians in the area. And then as for our third and final piece of evidence, it is their policy outlining when to search a suspect, which states that a suspect should be thoroughly searched as soon and safely as possible following the arrest. And it falls onto that arresting officer to search the suspect until a separate officer formally agrees to do the search in their place. It is also expected of them to search this suspect before transporting them.
Is that all you have?
Yes, that is all for now.
Perfect, thank you. Defense, do you have any remarks on the evidence provided?
Yes. First off, I would like to open on the fact that this was a blurry and grainy CCTV footage from a side being obstructed by the vehicle in roleplay. Therefore, you cannot get a clear sight of the suspect in the way that the prosecution was saying. The prosecution directly said that they were fully in handcuffs, visibly, posed no threat, was physically removed from the vehicle, and physically shot excessively. This, however, cannot be backed or proven based on what you can see from the footage. On the rebuttal of the fact that Jefferson Jeffrey should have searched the suspect beforehand, and that it is his own fault that the suspect held a weapon and was therefore posing a threat to his life, is false. Jefferson Jeffrey was in fact not the arresting officer on this case. He was simply transporting the suspect to the hospital by direction of the the arresting officer, whom was a Texas DPS trooper. Therefore, it is under the assumption taught in the Texas Law Enforcement Academy that those who arrest someone are those who are to be searched, unless put under discretion by the arresting officer or a supervisor. Therefore, Jefferson Jeffrey was in the correct, assuming that the suspect was already cleared and assuming that his vehicle was empty, and the vehicle was in fact empty. That is all I have on those remarks.
All right, I have a question for Mayor Jefferson Jeffrey.
Proceed.
Can you please confirm nor deny? Is that a Harris County Sheriff's officer shooting someone inside the video?
It is in fact the Harris County Sheriff's Officer firing a firearm at a dangerous suspect.
Perfect, thank you. You may be seated.
Thank you, Your Honor.
Prosecution, do we have any witnesses we would like to call to the stand? Platter?
The prosecution does not have any witnesses.
Perfect, thank you. We'll now move to defense's evidence.
The defense would like to open with a witness.
I would prefer evidence first.
All right, we're going to begin with evidence proclaimed to be released by the Texas Department of Public Safety, currently being released in the Texas Stage chat. This is a transcript of when Jefferson Jeffrey was unlawfully arrested on the 6th of July 2026. Arresting officer was Captain Vintage Dash. The dialogue reads, "All right, we have a warrant out for your arrest right now, sir, because you," also stuttered, "kind of, a murder in 1998. Jefferson Jeffrey responds with, "I was cleared of that multiple times." The captain responds with, "Well, ... multiple times, and multiple times again, we have found a loophole to get you out of custody." Jefferson Jeffrey responds to that by saying, "Your body camera's on." Captain Vintage says yes, while being interrupted by Jefferson. He says, "I have a fully warrant." I am unsure if that means, however, it is what the captain said. Jefferson Jeffrey confirms that you are saying that you found a loophole, and you're saying that on body cam. Captain Vintage does go ahead and confirm in the footage. This, legally, the legal definition of a loophole is an ambiguity or inadequacy in a system such as law or security, which can be used to circumvent, otherwise, or avoid the purpose of implied or explicitly stated for the system. Therefore, the reopening of this case was done not with the intent of the law in mind, and with an exterior motive.
The prosecution has an objection to this evidence in terms of its relevance.
Elaborate.
This evidence is on the arrest after the warrant was issued for his arrest, and not the incident itself.
Wouldn't the warrant be a part of this though?
This has no relevance to the crime itself, though. This is only
I'll sus-
body cam from his what is it? His arrest.
I'll sustain.
It has relevance. So, as shown in this clip of the body cam, the number of times that this has been reopened was through a loophole, going around the law as a way to get around the facts. Jefferson Jeffrey multiple times has been cleared of the wrongdoing by these crimes. Based off of the evidence provided today, there is nothing clearly new that we haven't known before. You know that there's a dangerous suspect that poses immediate deadly threat to our officer. As trained at the academy, he responded properly, saving his life by ending someone who posed an immediate deadly threat to him. This is taught in the academy, this is taught in any law enforcement training ever. If someone poses a life-threatening threat, you do whatever you can to safely stop that threat. And that is in fact what happened. Based on the information we know that these was reopened via a loophole, we're able to tell that what happened has no change. There is no change that he is not guilty. There is no change that makes him guilty. We know what happened, and we have known what happened. However, the Texas Department of Public Safety is using an exterior motive to reopen the case with not the interest of the law in mind in order to prosecute and possibly attack the public status of Mayor Jefferson.
Is that all?
Yes, Your Honor. We do have witnesses,
Okay,
however. Would that be later?
Prosecution, do you have any say with the evidence provided?
The Texas Department of Public Safety was within its full legal right to reopen the investigation after charges were not only dropped without precedence, but it was without prejudice, as well as it was found that the investigation that was conducted on previous openings of the case was incomplete and insufficient. And upon further investigation, we did find grounds to push the charges once again.
Objection evidence.
Sustained.
For one, we obtained that video causing the reopening of the case by direction of the colonel himself, as well as it was found during the third investigation that there was interference from the Harris County Sheriff's Department
Objection
on
evidence.
I'll sustain.
no rebuttal.
Alrighty. Is that all you have?
Yeah, that will be all.
Alright, we'll now move to defense's witnesses, if any.
I'd like to call on the state deputy director of law enforcement, Jack, to the stand.
That is not my name, but okay. Well, do you sort of tell a holder, don't not what you said, we got I do, or blah blah. Alright.
Wait, can you say your name for the record, please?
I am Law Enforcement Commissioner Jake Connor, badge number 1 Adam 1.
Alrighty, sir. Can you explain to me what the use of force title and chart labeled life-threatening can be described as in a situation that it might apply?
I would say that the suspect, the individual, is opposing a threat to civilians around and or other law enforcement officers with the use of a lethal weapon.
And what would you consider to be a lethal weapon? would you consider it just be a small firearm, or must it be something larger, such as a sub-automatic or automatic weapon?
It varies. It could range from a small pocket knife all the way up to a 50 caliber sniper.
And sir, with your experience in the field, how much time do you have to react once you see a threat?
Depends on the scenario.
If you see a threat of someone raising a weapon, possibly being aimed at you, or known to be being aimed at you, how much time do you have to react, sir?
I would probably say closer to a second.
And what is your response? What is it based on?
Normally it's based on suspects' movements.
And what knowledge and what base is the officer acting on when they make a response to said action?
Can you please clarify the question?
When coming into a situation like this and seeing such a possibly deadly scenario, what training does an officer act on that helps them decide whether or not or how they should respond to the scenario?
And we go through the police academy. We are learned to deal with these scenarios. We have over 100 hours of training within this specific topic we're talking about.
And during these trainings, is it true that you are taught if someone is aiming a weapon with the intent to shoot it or assumed intent to shoot it, that it is presumed to be life-threatening?
Indeed.
And what are you taught in the academy? If a weapon is being aimed at you, presumed to be life-threatening, what is the officer's response
Um,
taught in the academy?
depends. It depends on how heavy the scenario is. If specifically the gun is pointed directly at you already, and you don't have enough time to grab your gun already out, you're taught to try to de-escalate the scenario, and then if it evolves from there, you try to disable the gun from their hand.
And specific to this scenario, you do have the time to grab your weapon. Is that what the academy teaches you to do?
Most of the time, you will not have time to grab your weapon if the weapon is already being pointed at you.
So we have learned that if a weapon is being pointed at you, and you have a split second to react, you're reacting based on your training and knowledge of law enforcement, of danger, of threat, and of policing. And you're using that all in the span of half of a second to decide, is this person going to kill me? And if they do raise a weapon, known to be a dangerous and violent criminal, aiming at you, you have half a second to a quarter of a second to react. And as a good officer reacted, as demonstrated in this case, Jefferson Jeffrey, having the training and knowledge to react to this situation, was able to neutralize the threat to both him, his life, and possible citizens' lives around him, using his training from the academy, from his experience on the street, and from all of the experience that he has been granted and trained within the Texas State Police.
I have a quick
I would
question.
also,
Are
Yep.
are you claiming that Jefferson is the officer in the video?
am I claiming that Jefferson Jeffrey is the deputy in the video you're saying?
Indeed.
Yes, he is in fact the deputy in the video.
Okay, to clarify, so the deputy in the video did in fact shoot the suspect, yes or no?
Yes, that is confirmed, sir.
All right, perfect. Thank you.
No further questions for the chief.
Perfect. Thank you.
I would next like to call Jefferson Jeffrey to the stand.
What, do I not get cross?
Yeah. Yes, he does get cross-examination.
Then why do you walk away?
All right. Continuing from where the defense left off, if a suspect is holding a weapon but not raised, do we, according to as taught in the academy, what is the appropriate response to that situation?
You would try to get them to drop the weapon. But in that scenario, you should have enough time, because we're taught in the academy to draw your weapon quickly. At that time, you should have enough time to draw your weapon.
Do you automatically use lethal force immediately once a firearm is introduced?
Negative.
Where's the next one? Have you seen the video in question for yourself?
Yes, I have.
If you were to have a suspect that you suspected had a firearm in the backseat of your vehicle, would you remove them from your vehicle?
Depends on specifically where the firearm is located, but I would try safely to I would at least get out of the vehicle myself for my safety.
If you had
But it
a
depends on exactly where the firearm is located within the backseat. If it is on his person, if he has the ability to reach.
if you have a suspicion that your suspect has a firearm due to their movements and sounds that you may be hearing from your back seat, would you remove them from your vehicle then?
Yes, I would.
If you found that they did in fact have a weapon in their hands, what would be your response to that?
I would confiscate the weapon, put it in logging, and I would talk to the arresting officer, because clearly they didn't do their job right.
You would not use lethal force against a suspect who is handcuffed but has a weapon in their hand.
If it is not particularly, no.
No further questions.
I have a question for the witness.
Go ahead.
If a weapon is being aimed at you in handcuffs, does that still justify that you should not, in fact, respond?
I would respond if the weapon is being aimed at me.
As testimony by the witness has said, the weapon was in fact aimed at him while the suspect was in handcuffs. During the transport ride, the suspect was able to slip his handcuffs over his legs to have his hands in the front. While having his hands in the front, he was able to hold a firearm and physically aim it at the suspect. Is that a justified time to use lethal
Objection,
force?
facts, not in evidence.
The
No
evidence
one has
is the interview done by the Texas Department of Public Safety.
the
I don't
interview
believe I need
itself.
to enter the interview if it was already part of the case.
The interview was not entered into evidence. Only the body cam of the arrest was.
Jake, what do you say? There
Continue
was two
farther on your
interviews.
question.
So if a suspect was to be able, while still in handcuffs, does someone still have movement over their hands and fingers?
While in handcuffs?
Yes, sir.
Yes, they do still have movement over their hands and fingers, correct?
And what movement do you need to fire a weapon?
Your hands and fingers, I would assume.
And what movement do you need to have to raise a weapon and aim it?
Just arm control.
And does a handcuff restrict that movement when
Not
the hands are in
particularly.
front?
Not
So,
particularly.
is it, in fact, reasonable that what we have suggested. Let me rephrase that. Is it reasonable for use of force to be used when a weapon is being aimed at you? When the person is wearing handcuffs or not being handcuffed? If this person's wearing handcuffs and a weapon is being aimed at you with the intent to kill, does that change your response?
If the weapon is being aimed directly at me already, in the academy, you're trained to try to de-escalate the scenario before you draw your weapon, because drawing your weapon takes time, and within that time of drawing your weapon, you can easily get shot.
Is it in fact possible for one to hold a weapon while in handcuffs? And does that change the response you should make on the situation?
It is possible for a individual to hold a gun while in handcuffs, but no, that does not change my answer.
So if someone is in direct immediate threat of risk and you are able to take a shot or take a threat and neutralize it, as Captain Jefferson was able to do, or then Deputy Jefferson, as he's been on the street, he's able to have a quick reflex in his arm, and he was able to respond to that. Therefore, he knew that if he didn't respond fast as he did, there was an immediate threat as the weapon was being aimed at him. It was being raised and aimed. When you have a split-second decision, do you have time to negotiate with that suspect in that split second?
It is preferred that you negotiate.
Do you have time to negotiate in half a second?
Negative, but you also should not be drawing your gun, because the time it takes you to draw the gun is the time it takes from a bullet to get shot from a gun and also kill you. And if a suspect sees you drawing your weapon, they will shoot and they will kill you. Now, don't get me wrong, what Captain Jefferson did is beyond skill, but that is not what you're taught in the academy.
What exactly is it that is against what you're taught in the academy?
Drawing your weapon in that scenario. Granted, yes, is it good to neutralize the suspect if you have a gun pointed at you? Yes. But most of the time, you are not going to have enough time to draw your weapon to neutralize the suspect before the suspect shoots and kills you.
If it is a known violence or aggressor, such as known to be, and such as known via the bruising, and reason the suspect needs to go to the hospital was for violence towards another officer, is it reasonable to believe that there is more violence that this officer would like to have, or this suspect would like to have even more, as he just got arrested and now wants to get revenge and also wants to continue what his original intent was? Is that reasonable to believe?
No, you could say that. Any further questions from the prosecution?
The prosecution doesn't get another go.
All right, defense, do you have any more witnesses you would like to call to the stand?
I'd like to call Jefferson Jeffrey to the stand.
Alrighty. Test Jefferson Jeffrey, can you please come stand over here real quick?
Yes, Your Honor.
Alright, please raise your right hand and place your left hand on the Bible. Do you swear to tell the whole truth and nothing but the truth, so help you God?
Yes, I swear to tell the truth, the whole truth, and nothing but the truth, so help me God.
Perfect. You can go ahead and take a seat.
Alright. Can you say your name for the pug, sir?
Jefferson Jeffrey.
Right. And Jefferson Jeffrey, what do you consider to be life-threatening from a police standpoint?
if an action that is being done or can easily be done by the suspect given the current circumstances put a live civilian or law enforcement at risk.
And what would you consider a tangible threat that puts someone at immediate risk of life be?
Well, like I said, an action that can be performed by the suspect that would either end an individual's life or permanently leave lasting injuries.
In this scenario, is it true that this firearm that the suspect was aiming at you could have killed you?
Yes.
Now, I understand that this was over 20 years ago. Are you able to remember what thought went through your head in that half second that you could have died? Do you remember what went through your head too?
To immediately exit the vehicle.
Why was that?
Because I saw what I was almost certain was a firearm in the hands of the suspect that was being pointed at me, and I wanted to, avoid being shot at.
And with that being known, is that why you had time being shielded by the vehicle to draw your weapon as you moved to protect yourself?
Yes, the time it took me to go around the vehicle to what I had hoped, I was hoping to be able to subdue the suspect peacefully, but the time that I had to go around to do that, I didn't have time to draw my weapon.
And during this time, did you feel that the threat to your life rose or grew in any way?
During that time, no. But
Do you feel that there would have been a possibility to negotiate with this person who had such an intent to kill you?
no, the suspect had too much freedom of movement.
And in the academy, what are you taught to respond with someone who poses direct threat and will not negotiate?
Well, if possible, to open fire.
Is that how you respond?
So I didn't hear that question.
Is that how, in fact, you responded?
Yes, once I saw the firearm pointed directly at me, I believe the. Oh goodness.
Now, please continue.
Okay. Once I
Go
saw,
on.
it's kind of loud.
It is kind of loud. You're noob. Glamour dude. Gamer.
Clamor. Yep, kick clamor.
Alright. Sorry, continuing.
Okay. I'll just do the courtesy of waiting for the judge to come back. Okay.
Alright, please continue.
Yeah. So as I saw the weapon pointed directly at me, I had already my weapon drawn on low ready with one hand. The only option that I saw was to grab it with both my hands and open fire on the suspect to protect my life.
Alrighty. And is it true that you still have continuing education in policing to the day?
Yes.
So, has the training changed from law enforcement perspective on the terms of use of force and life threatening in these 30 years since the investigation?
Yes. Nowadays, policy is much more centered on preserving the suspect's life than it was 20 years ago, evidently. You can look at the drama and the news headlines back then to learn more about that, but I'm not going to get into more detail.
Based off of what you know and based off of the evidence that was released, the very grainy video that is quote unquote why this investigation was reopened, does that spark any controversy or any rationale based on modern day practices?
Absolutely. I mean, I wouldn't do the same thing I did back then today due to that policy change, but I still believe it was a solid choice on my end, and the outcome, unfortunately, would have been the same.
Based on your training to the day and your continuing education, how would you have acted differently?
I would have attempted to call for. Well, looking back, I don't. Thinking more about it, I don't think I would have. Um, Especially with the more factors you consider, such as backup time responses and the cover I had available, which was none. In case some of you here watch a lot of Hollywood movies, cars are not bulletproof.
And is it true that when in a life or death scenario, you act on whether you want to believe it or not, and whether it's good or not, you act, and there's definitely a sense of instinct in it?
Sorry, could you repeat your question?
Do you believe that when you are in a life or death or very risky scenario, your response, backed by training, commonly has instinct? In these scenarios where you have half a second to respond, is instinct a driving factor?
Yes, when faced with a situation where your life could possibly end at any moment, your brain immediately falls back on training and instinct from that training.
And based on that, do you teach officers to second guess themselves and get shot?
No, I do not train uh, new deputies to second guess themselves in active shooter scenarios or scenarios where others or their life is in danger.
Therefore, when making a scenario in a response to an ever growing threat on your life, is the proper response, if possible, to negate that threat in the fastest possible way?
If when there's a threat to my life, my duty is to negate that threat. Is that the question?
If there's a threat to your life that's ever growing, is it the responsibility of the law enforcement officer to remove that threat in the fastest and safest possible manner?
Yes.
I yield my time.
Prosecution.
Are you the deputy shown in the video?
Yes.
Is that your patrol car that is shown in the video?
At the time, yes.
When exactly were you able to visually confirm that your suspect had a firearm?
When I looked back.
Was that when you were inside or already outside of the vehicle?
That was when I was inside the vehicle. I looked back and because I heard noises and I saw that it was being aimed at me.
When you exited the vehicle and came around, did you remove the suspect from the vehicle? Like,
No. He was able to remove himself using the weapon.
how was he able to remove himself from the vehicle? From a vehicle with no door handles?
I'm uncertain. There are many aspects of this investigation that I was not that I am not aware of because yeah, people that are subject to investigations are not told all of the details.
But he was able to exit the vehicle, correct?
Yes, when you have a certain type of weapon or lethal weapons, a grand majority of the time you are able to do damage to property that allows you to do a number of things, including break things, like opening a door.
And according to your statement just now, you used a firearm, and only a firearm, to open this door.
The suspect, yes.
Yes, suspect. In the video, the audio is slightly distorted, but still audible. Was it or was it not you who yelled, "You have pissed me off," quote unquote, not once but twice during the in the evidence?
No, I deny these allegations.
The prosecution would like to request to review the video once again.
Yeah, we can go ahead and review the video one more time.
Are we ready to
Action
continue?
CCTV cameras from 1998 do not have cameras. Sorry, do not have microphones built in, so that there is a question of the legitimacy of the audio present.
We
Alright, please
had
just listen.
previously agreed that the camera did in fact have audio, and we did distort it to make it less hearable.
Alright,
At
everyone, please
approximately
be quiet and listen.
3 seconds in the video, please.
Chan, I'm dead. I drowned. I drowned.
Right there.
So at 3 seconds in the video, that was not you remarking, "You have pissed me off."
You can leave me down there.
Have I?
Fucking guy. Ban him.
Jefferson, at 3 seconds in the video, that was not in fact you yelling, "You have pissed me off."
Well, the audio is too spotty for me to be able to clearly tell, but I have no recollection of ever saying such things, and I don't see why I would have said such things.
The first time is spotty, but we do more or less clearly hear it during the second one. We do hear "You pissed me off" being stated the second time.
I do hear
Okay.
it, but that's not what I said.
So the suspect exited the vehicle. Did he then once again raise a weapon towards you?
Yes.
And what happened to this weapon after you shot this detainee?
I'm unaware.
The prosecution would like to say that there has been no evidence that any weapon other than the deputies was entered into evidence for the case in question.
I believe that is correct.
And no further questions.
Alright. Defense, do you have any further questions?
I'm just asking, what evidence specifically are you looking for?
The detainee's
I swear to God.
so-called firearm.
I thought he was banned.
There are multiple, apparently. Who it is?
Who's this disclaimer? No one. He didn't get banned.
Okay. My bad.
There were no
Anyways.
DPS nor HCSO records of a firearm other than the deputies being entered into evidence.
And based on that, is it possible that the suspect may have been able to throw the firearm or discard of the firearm in a sense that it was unable to be found? Jefferson Jeffrey.
Yes.
So, the legitimacy and accuracy of cases 30 years plus old and looking for one gun that is in fact 30 years old cannot be very accurately stated and questioned and witnessed based on this court. Therefore, I wish to discard that evidence.
There is no evidence. There's a lack of evidence.
More so the argument than the evidence.
Wouldn't the investigations have looked over the scene?
They should have. If they didn't, that'd be a whole different can of worms, though.
If I'm correct, there
rebuttal-
was an investigation report about the. There was an initial investigation report, correct?
What department conducted this investigation? Like, this is going on territory that we're making stuff up, so it's kind of hard to make arguments on it.
Let's see, Texas DPS reopened the case, so it would have had to been originally a Texas DPS file.
And is it not true that the original is it not true that the suspect was originally in DPS custody, Jefferson Jeffrey?
Yes, the arresting officer was from the Texas Department of Public Safety.
Is it possible that corruption during that time, as you said, during your examination between you and the director of public safety, there was a perception of corruption within the department from the public and everyone else? And is it possible that the department did not register a gun or intentionally did not put this evidence in the case as they did not want to hurt their department or the public perception or have any tie to the mistake they made of not originally searching their suspect in the first place? Is that a possibility that could have happened?
Objection. This calls for massive speculation on the part of the deputy. He was not part of DPS. And there is no
Speculation,
proven
perception,
corruption.
Overruled.
Speculation is not what this is. We're using information that has been said and used during the case, and it's public perception. It's not one person's opinion. Now, if you could answer the question.
Yes, it is entirely a possibility.
I have no further questions. I yield my time.
Alright, perfect. Alright, we'll now allow for a 5-minute recess, and then we will please meet back in the room for closing statements and findings and,
Everything go to scene 2. But that was like very grainy. The entire like thing was.
Well, we should
It
go into the hall.
Ace.
We should go into the hall.
I thought that they had no like. They just had speculation based video, like no audio, no direct sight of anything, no nothing.
Okay, well, no offense, but your investigation was horrible then. I mean, all of this has been
I
public
had no
information.
investigation. I tried to talk to Vintage, who was the investigator, and bro would not tell me shit.
I mean, you questioned me with like the board of law enforcement.
Yeah, and we were questioning if this was a political thing, not if you were actually guilty or not.
Okay.
We were trying to figure out if this was open as a political attack towards you by a political enemy.
And what did you find?
That it was and wasn't really. I would need to go back through the actual document. I don't think we ever had an official finding. But this evidence, it doesn't help us.
Yeah, but it's not terrible either. Like we can survive this.
Fail.
This might be bad, but the prosecution is a joke.
He did make a couple good arguments.
Yeah, but that we mostly were able to destroy. Well, I say we, it's you.
I'd like to think that, but I also want to be realistic.
All right, well, I guess, let's just go face the
So
music.
if we have a closing argument, what do you think I should highlight?
That I did what I was trained to do, and what I am training our new deputies to do today, I guess. Does that work?
Sure. But if you say that it wasn't indirect fire, like I was so like that would have gone you in deep shit.
No, I mean, like, not in direct fire as I was going around the vehicle, but like while I was in the driver's seat and while I was opening the door. Yeah. Well, I guess it's when that he got out, pointed it, but yeah.
Any questions for me based on anything I've done or said?
Do I do I have to do anything more, or is it just you yapping?
Sit back and watch, I think.
What?
You should be sitting back and watching, I think.
Okay. Well, then I guess it should be fine. Just keep feeding me answers in case I do have to say anything.
You shouldn't have to say anything else, but if you do, I'll let you know what to say. But if you seriously don't know, be careful how you say this, but you wait.
I'm too nice. I try to tell too much of the truth.
Okay, if you need to pull this out and you don't know how to answer a question, say, by the advice of my attorneys, I yield the Fifth Amendment right to self-incrimination. I'm not going to say something that I cannot fully guarantee, and end it there.
Okay.
Are you going back, Jake?
Your time is up. All right. We will now be moving to our closing statement. For this, we will be starting with the prosecution.
Yes. So, throughout this case, we've seen the evidence, we've heard the testimony, and two things are immediately clear about this case. The mayor, Jeff Jefferson, was in fact the deputy who fired their weapon on this detainee. And he also did do this with intent to use lethal force. But one major question still remains. Where is the suspect's gun? Where is this firearm that their entire defense revolves around? There, they presented theories, which is in the name, are only theories. But with the expectation that this investigation was mishandled, tampered with, or of all things, accusing corruption as a means for this weapon being missing without any evidence to back this story up, merely stating the detainee threw the weapon away and DPS hid it because they're corrupt, because we think they're corrupt, does not show that they have any idea where this weapon is either. It may have been 30 years ago, but at the same time, a proper investigation was conducted 30 years ago and was not pushed at the area for whichever reason they decided to at the time. It was reopened now, legally, due to these unfollowed up investigative leads that were not followed up with at the time, and allowed the Department of Public Safety to repush these charges once again, as the case has not been dismissed with prejudice by any means, and does not fall under the category of double jeopardy. We heard
Is that all? All right, perfect.
we heard from
Yes.
the Deputy Director of Law Enforcement, as well as Jeff Jefferson himself, and as stated in the HTSO policy, the use of deadly force by a law enforcement officer requires that there be a immediate and direct threat to the life of someone else. Yet they have failed to provide any evidence on the fact that this actually existed, with the only thing being the testimony of the officer in question. And that is why we ask that you consider this lack of evidence in the defense to help come to your decision when what is it? Deciding on your judgment.
Verdict.
Yes. Deliberation. Take this into account during your deliberation. Along with the defendant himself hesitant to answer the specific question on the audio from that security questions when asked. When asked if he said the words, "You have pissed me off," his hesitance to answer that question, not once, but twice, the first time before and after reviewing the footage, he, as coming on the stand, does in fact waive his Fifth Amendment right, and therefore his silence can and should be considered as part of his answer and part of his reluctance to acknowledge this question. That will be all. The prosecution rests their case.
Perfect, thank you. Then, so it is now your time for your closing statements.
Today we have made a number of statements regarding the facts of this case. This case is 30 years old. The facts are outdated and need to be reviewed. And they did. And, in fact, we found that they're not outdated. And that this case, all 3 or 4 times that it has been reopened, has come to the same finding. Jefferson Jeffrey is not guilty for murder. He is acting with what he was taught in the academy, what law enforcement officers act and are taught on. As we have shown evidence time after time, we have shown proof, we have shown testimony, we have shown paperwork. Jeff Jefferson Jeffrey responded how he should have, how he was trained to, how law enforcement officers are expected to. On the road, you don't have time to call everything in. You don't have time to be a perfect officer. But they teach you how to perform under stressful environments and how to be a good officer and how to be an outstanding officer. And based on Jeff Jefferson Jeffrey's experience and based on his training and based on his knowledge, he was able to adequately and properly respond to the situation by neutralizing the threat that was directly engaging on his life. I'd also like to say that the prosecution both said that there was a thorough investigation, that they did not find a gun in, while also saying that they did not consider the camera that they saw. So, my question is, how could it be thorough if they didn't think to look at a camera? And now that we do go thorough, we find the same findings. We find the same results. We learn nothing new, only of his innocence and only of his torture and pain that he's being put through. We learn that time after time again, he will be attacked very viciously via the judicial system. However, we know and we understand that the findings will not change and the truth will not change. Jeff Jefferson Jeffrey acted on his training and experience as properly and as trained as a law enforcement officer to protect his life by neutralizing a threat. Thank you, Your Honor.
Yes. Alright, please give me a minute or two to decide my verdict, and then I will get back to you all.
We should deafen him, so then we can say whatever we want. I feel like you shouldn't be able to deafen the server owner, but sure, I guess you can.
What up? It's a nice beard you
I'm
got
here.
there.
Matches my hair, right?
Yeah. Are you on our side now? Do you agree with us?
I entirely disagree. No gun is no gun. I don't know.
You also said that was thorough, but you also said that they missed a
Okay.
literal.
That's a good point.
Alrighty.
You just said they're corrupt, though.
The judge has reached his verdict. Okay, so, given the evidence provided in the witness testimonies, Mayor Jefferson Jeffrey, on the count of first-degree malicious murder,
First degree, what?
yes, it would be first-degree murder because it's malicious intent.
But doesn't that say it's pre-planned and premeditated?
Well, that also, but I don't think Texas has degree murder. It's just murder. You just have to prove that they wanted to kill someone.
It's U.S. It's all under U.S. law.
Capital
It's
murder,
not
murder, and
Texas
homicide.
law. Or...
No, it's not capital murder. I tried. I tried hard. Trust me. I couldn't find a way to make capital murder work.
Mm-hmm.
Anyways, the account on murder, Mayor Jefferson Jeffrey is found. Hold on. Sorry. Give me like 1 second. sorry. Um, Jefferson Jeffrey is found guilty of murder. He is sentenced to 25 years in a medium security prison, with no parole.